I'm going to call the meeting to order. Bienvenue à la réunion numéro 144 du Comité permanent de l'accès à l'information.
Welcome to the Standing Committee number 144 of the Ethics and Privacy Committee, pursuant to Section 108(3)(h of the Standing Orders, and in accordance with the motion adopted on Thursday, November 21st, the committee is commencing a study of the wind-up of TikTok Technology Canada.
We've got Mr. Philip Dufresne. Welcome back, Mr. Dufresne. I hope you went home and were able to come back. We had you here on Thursday. And then Mark Phillips, the Privacy Commissioner of Canada, and Mark Chenier, who is the Deputy Commissioner and Senior General Counsel. Now, just before we begin with your opening comments, we do have a study budget for this. I'd like to get this adopted now. It's for $1,750 for this study. Is there any objection to the study budget from members of the committee? No? No?
Sorry, Chair. Can you just outline what exactly that money was spent on?
Yes. Headsets, 3, $250 each. Working meals, $500 each for a total of $1,000. That's $1,750. Okay? No objection? I don't see Mr. Green, but I'd like to see him, please, because I don't have any indication whether he's objected to this or not. Okay. I'm going to come back to Mr. Green, so I'm not going to adopt this now. I know I have the consent of the rest of the members, but once he's on, we'll figure that out. Mr. Dufresne, commencez, s'il vous plaît, pour...
Mr. Dufresne, you have 5 minutes for your opening statement. Good afternoon, ladies and gentlemen and committee members. Thank you for inviting me to appear as part of your study on the government's decision to order the liquidation of the Canadian business carried on by TikTok Technology Canada Inc. I welcome this opportunity to contribute to the important discussion on national security and privacy in the context of foreign ownership, control or influence of digital platforms, including social media, and foreign property or foreign control.
To order the wind-up of the Canadian business carried on by TikTok Technology Canada Inc. This decision was made pursuant to the Investment Canada Act, which allows for the review of foreign investments that may be injurious to Canada's national security. According to the guidelines on the National Security Review of Investments, these reviews may look at a number of factors, including whether a foreign investment could facilitate access to sensitive personal data, including personally identifiable health or genetic information, biometric information, financial information, private communications, geolocation, or personal data concerning government officials. This assessment is made by the government, and my office was not involved or consulted with respect to this assessment. Indeed, we learned of it when it was announced publicly on November 6, 2024. Comme vous le savez, en février 2020,
as you know, in February 2023, I launched an investigation into the TikTok social media platform, along with my provincial counterparts in Quebec, British Columbia, and Alberta. We're examining whether TikTok's practices comply with Canadian privacy legislation, and in particular whether valid and meaningful consent is being obtained for the collection, use, and disclosure of personal information. Given the importance of protecting children's privacy, the joint investigation is focused on TikTok's privacy practices as they relate to younger users.
From our investigation into TikTok will be informative not just for that company, but also for other organizations that collect and handle children's sensitive personal information. The government's decision to order the wind-up of TikTok Technology Canada Inc. does not impact my authority to investigate. We are nearing the end of this investigation, and my goal is to have it concluded in the next few months. As the investigation is ongoing, I am limited as to what else I can share at this time. Championing children's privacy, addressing and advocating for privacy in this time of technological change, and maximizing our impact are my 3 strategic priorities for the Office of the Privacy Commissioner. To this end, in October of this year, I issued a statement with my G7 counterparts on artificial intelligence in children. The statement highlights the importance of ensuring that technologies such as AI be developed in a manner consistent with the best interest of the child. Pour atteindre cet équilibre important,
Achieving this important balance between innovation and the fundamental right to privacy requires a concerted effort and collaboration across jurisdictions to support and empower individuals to be active digital citizens confident that their fundamental right to privacy is protected. We do this by setting the parameters that will help organizations to innovate while building a culture of privacy in which privacy by design and privacy by default principles are woven into the fabric of their activities. I will conclude by thanking and commending the committee for its most recent support entitled Oversight of Social Media Platforms, Ensuring Privacy and Safety Online, which was released last Thursday.
that are good for privacy, good for Canadians, and good for the public interest and innovation. I look forward to sharing and discussing these important insights with my counterparts in Canada and internationally. Thank you again, and I'd be happy to answer your questions.
Okay, thank you, Mr. Dufresne. Before we commence with Mr. Barrett, I've got Mr. Green online. Mr. Green, we went through a study budget here of up to $1,750. Doesn't mean we're going to spend it all. Whatever we don't spend gets put back to the House, but that's for working meals and headsets. We may or may not need them all. Are you okay with that? Okay, so I have the consent of the committee, Madam Clerk, so the study budget is approved. And Mr. Barrett, you have 6 minutes. Go ahead.
Mr. Dufresne, what are the potential risks with the privacy and data of Canadians who continue to use TikTok?
Well, we are investigating the consent practices, transparency of TikTok. The investigation is underway, so I can't speak about the substance of that investigation, but when we announced it, we did indicate that it would have a specific focus on children's privacy and younger users. So we are working hard with our colleagues from Quebec, British Columbia, and Alberta to complete this as soon as possible, and I hope to do so, as I said, in the next few months.
So we're in a very, I think that there's a bit of a problem for Canadians who are trying to make an informed decision for themselves, parents who are trying to parent their children, for children who are trying to make informed decisions for themselves. We have a government who has said, this app is okay for you to continue to use. However, the offices of this business that operate this platform must be closed. And there are specific risks, but we can't tell you what they are. So it's a complete absence of transparency. Now, you're an independent officer of Parliament, and so you serve a function that's important to help keep Canadians informed, to help be a check against some of what government does. Should the government have been more transparent with Canadians on a matter that deals with the protection of Canadians' privacy? And should the government have aligned their decision and announcements with the release of your report?
Well, the government's decision announced on November 6th by the Minister of Innovation indicates that this is made under the Investment Canada Act. It's made on national security reasons. So our investigation is a different track. Our investigation is looking at the privacy of Canadians, in particular children. So we're moving that forward, but the national security component is a separate aspect. So I can't speak to that decision and to the reasons behind it. I wasn't part of it. I wasn't consulted on it. What I can say is that we have issued, myself and my colleagues from the provinces and territory, a statement on the privacy of children. And we make a number of points in there in terms of setting out our expectations for organizations, giving tips, highlighting certain things for parents and children, making sure that the privacy protections are highest, calling out organizations when their practices aren't clear enough. So we're going to continue to use the tools that we have, which is the promotion and the investigation power, and look forward to completing that.
So I'm interested in your investigatory powers. Now, the government has ordered the closure of the offices of TikTok in Canada. So who are you going to investigate in the future if there's an issue raised with respect to TikTok? if they have no presence in Canada, if they terminate, as has been the order of the government, for very opaque reasons, and we have no metric, and we have no measure to be able to judge whether those are good reasons or not, but they've ordered the closure of these offices, who would you investigate? Who would you ask for documents from? Foreign entities? And would those foreign entities have any obligation whatsoever to participate or cooperate with your investigations?
So Canadian law will apply to a matter if it impacts Canadian users. So it's not necessary for privacy law in Canada to apply for an organization to have offices in Canada or for it to have generated in Canada. So the courts have recognized if there's a real and substantial connection to Canada, and that could be having Canadian users, having Canadians impacted by this, then we have jurisdiction. And so how we investigate those things, if the organization doesn't have anyone in Canada, then we would reach out to the organization in other countries.
So you reach out to them in another country, and they say, contact our Canadian office. What do you do?
Well, we reach out with the organization in the other country. If it doesn't have a Canadian office, then we would speak to them outside of Canada.
I understand that, sir. But what with all due respect, what jurisdiction does an officer of the Parliament of Canada have in China?
Well, we don't have any enforcement powers in other countries. We don't have the ability to force an organization to collaborate with us or to provide us with information if they're outside of Canada. So
it seems a bit problematic then, you might see what I'm driving at here, for us to have no entity in this country for you to collaborate with, as you said. Like that creates a problem, no?
Well, certainly in terms of compelling powers. Right. If there's a refusal to provide us with documentation, it's easier if the organization is in Canada.
Yeah, I expect it would be easier. And so it just seems odd that the government would say, this is so dangerous that we have to close the office, but it's okay for children to continue to use the app. So I guess what I'm driving at here is they need to pick a lane. Either it's okay, it's safe for Canadians, or it's not, and we just don't know. Isn't that a problem?
Well, I'm focused on the investigation that we're pursuing. So we're interacting on this with TikTok. We're asking the questions. We're going to be publishing our report, as I say, as soon as we can. And that will contain our conclusions in terms of compliance with Canadian privacy law.
Okay. Thank you, Mr. Dufresne. Mr. Barrett. Ms. Khalid, you have 6 minutes. Go ahead, please.
Thank you very much, Sharon. Thank you to our witnesses who are appearing today. Thank you, Commissioner. I'll start by asking, from your understanding, the government's decision with respect to the Investment Canada Act to review, how does that relate to TikTok's? Sorry, I'm going to rephrase this. From your understanding, the government's decision under the Investment Canada Act review relates entirely to TikTok business operations, not the app itself. Is that correct?
Well, as the decision is announced, it is not closing the app. It is calling for the wind-up of the Canadian operations of TikTok.
Can you expand on that a little bit? What does that mean?
Well, I haven't seen any order from the government banning the app in Canada or preventing its use. It's calling on the organization to cease its corporate activities in Canada.
Does your office play any role with respect to the ICA's national security review?
No, we're not involved in that decision. This is a decision that's made by the department, I believe the Department of Industry, in consultation with national security experts in the government, and ultimately a decision of the executive.
And are you normally consulted as part of the ICA national security review?
We were not consulted in the context of this specific decision. We could be consulted in terms of general operation privacy impact assessment about the program itself, but this decision is not a decision that involves me, and it's not a decision where I would have been able to provide privacy input.
So to change channels a little bit, so I think you and I are both of that generation where we have experienced life without the internet and experienced life with the internet and digital technologies. I think basically everybody around this table is of that generation.
Maybe not mine.
Oh, maybe not Mr. Caputo, but or. However, but there have been concerns that with TikTok leaving their operations on Canadian shores, that it will heavily handicap your oversight with regards to the app and with any data violations. However, it's my understanding that your office can assert jurisdiction over foreign companies without a physical presence in Canada. The physical location of servers is not determinative of your office's capacity to do your job. Is that correct? And can you explain that?
That's correct in the sense that for me to have jurisdiction over a matter, there needs to be a real, what the courts have called a real and substantial connection to Canada. And that could be by looking at things like the location of the target audience of the website. So if they're Canadian users, then that factor is met. The source of the content of the website, the location of the website operator, the location of the host server. So it is a contextual assessment, but we usually get jurisdiction when Canadians are affected by this. So Canadians are using the app, then we take jurisdiction. Where it can have some aspects of more challenges is if there's a time to enforce the decision, there's a time to compel things. If things are in another country, then we need to use the courts of that other country.
So if TikTok does not have an office in Canada, can you still have jurisdiction over their operations in Canada?
Well, we still have jurisdiction to investigate the website, to investigate the impacts on Canadians, to investigate whether this complies with privacy practices, and we have jurisdiction to make an order and to seek a court order from Canadian courts. Where the issue could come up is in terms of enforcing it. If all the assets are in another country, then it becomes an issue of private international law where you seek to have another court of another country enforce a decision of Canadian courts.
And what kind of enforcement measures do you think would need to be taken in this instance?
Well, at this instance, we are still conducting our investigation. We're going to be issuing our report of findings in the coming months with my colleagues from Quebec, BC, and Alberta. So I won't say more about that. We haven't finalized the outcome, but the outcome of an investigation, in my case, I don't have order-making powers, but it could be recommendations. I could take action before Canadian courts. My colleagues in the province have order-making powers, so that's an issue that would come up at a later date.
And is that something that the RCMP would get involved in once your investigation is completed, or would that be a civil case that you think would need to endure?
Well, our investigation would not involve the RCMP, so we conduct our investigation, we issue our report, and then if there is a finding that the law was breached, if there are recommendations or for the province's orders, or if we take the matter forward to court, then it becomes a civil proceeding.
Okay. And are there any recommendations that you have to make to this committee with respect to how we should conduct ourselves, not just with how TikTok has operated and with this move, but also with other social media platforms as well? Is there anything that you think that we can be doing better to legislate better protective supports for our communities and our country?
So we're over time here. I'm going to have to get you, Mr. Dufresne, to circle back on that response, if you don't mind, in the next round of Liberal questions. We're 28 seconds over on that one. So, Monsieur Villemure, pour 6 minutes, s'il vous plaît.
Merci beaucoup, Monsieur le Président.
Mr. Villemure, 6 minutes. Thank you, Chair. Thank you for being here with the Commissioner, Mr. Chenier. There are some paradoxes here. We're being asked to do one thing and then another. I won't go into the details that you went over, but what do you feel about the government's decision stating that we're expelling TikTok from Canada but use it anyway? Now, it's difficult for me to comment on the decision because I don't have the information that the government had in making it. We saw the minister's statement to the effect that the decision was made pursuant to the Investment Canada Act. So I can't judge other than to say that we at the same time are continuing with our investigation on TikTok to determine whether Canada's privacy legislation is being respected, particularly with respect to young people. Without revealing what you can't about your ongoing investigation, it seems to me that this decision isn't really helping you much. In fact, it's complicating your work. At this stage, as I said, we are continuing with our investigation. It's not having any impact on that. We will be able to conclude our investigation in the coming months and to come to a decision. What was being discussed with your colleagues was this: should there be non-compliance or a refusal on the part of TikTok to cooperate, would it make it more difficult to achieve enforcement if there's no entity in Canada? Possibly, but we're continuing to use the tools we have available. Could the power to issue orders be useful in this kind of situation? Yes, of course, issuing orders is lacking in the Canadian legislation, and you said this in your report. It's something that is highlighted even when we compare ourselves to some provinces within Canada. And certainly when we compare ourselves to other countries, for example, in Europe, we are presiding the G7. I will be chairing the meeting of my counterparts. What this means is that we'll have to go to the courts, use legal resources, use pressure, and it'll take time. You talked about the possibility of class action suits and significant agreements. Well, that is what attracts the attention of leaders. Could orders be issued with the legislation as it stands? Yes, I could issue an order, but I couldn't impose a fine. The fine would be a recommendation that would be referred to a new tribunal that would be created, which would then have to decide whether to impose the fine. It seems paradoxical to bring in new legislation on privacy when there are precedents. There is legislation here and elsewhere that works. With regard to CSIS, the personal data of users on TikTok is available to the Chinese Communist Party. How can we better protect Canadians? One of the recommendations we made with C11, which was the bill before C27, and we reiterated this in our report, was that there be more specific rules on international data transfer. At present, the legislation is quite general. It says one must, by contract or by other means, ensure that there is compliance with what is being done in Canada. Countries in Europe have a more stringent regime. There is a process whereby the legal system in another country is assessed, and then a determination is made as to whether privacy is being adequately protected. That system could be more stringent and would provide greater protection. Speaking of international data transfer, there's an Israeli company working with a Quebec company. It's a Mesayu. It's a gene analysis company. What about those data being shared? We have handed down decisions on some of these issues, cases where a third-party supplier is being used in a third country. That's allowed under the legislation. Data can be transferred outside the country, but equivalent protection must be provided. So in cases like these, we decide or determine whether the consent given was for the same ends as the data is being used in the other country, where users at the time of consent, given proper explanations, are told that data might be transferred outside the country and why. In that case, we found it to be acceptable. In other cases, you'd act in the case of a complaint. Yes, we could launch our own investigation, but usually it's in response to a complaint. If there was a concern about lack of transparency or data being used for different ends than those they were purportedly going to be used for, yes. Thank you, Mr. Villemure.
Go ahead, please.
Thank you, and welcome back, Mr. Dufresne. Certainly a lot of really interesting and probing questions here. You mentioned in your opening remarks that the decision by the government was made pursuant to the Investment Canada Act, which allows for a review of foreign investments that may be an injury to Canada's national security. You went on to say that the guidelines for the national security review of investments include a number of factors, including whether a foreign investment could facilitate access to sensitive personal data, including personally identified health or genetic information, biometric information, financial information, private communications, geolocation, and personal data concerning government officials. You also went on to make the distinction that your investigation is targeted primarily to younger users. I would ask that if the government makes such an alarming declaration based on those guidelines to actually ban a company from this country, why haven't you also undertaken to look at some of the issues which may be related to the review of foreign investment that might injure Canada's national security?
Well, we're focused on the application of Canadian privacy law, and in this case, we're focusing in particular on the protection of children. This is one of our priority. It's a priority that's shared with my colleagues in the province. We've issued statements on this, and so we're moving forward on this. The national security aspect is a different matter, and there can be some overlap in some respects, but that one is the one that's being taken on by the government. We saw that as well when the government took the decision to ban TikTok from the devices used by government employees, for instance. So that decision was made and announced a couple days following my investigation. So they're different tracks, and they're moving forward on that. And again, if there are some aspects in our investigation that touch upon foreign access or otherwise, then we could.
Well, let me put the question another way. Let's say the government didn't make this decision. Would it not at least warrant an exploration? These are very serious accusations, and the guidelines seem to have what I would describe, and maybe you can confirm whether you believe this to be the case as well, what could be considered a form of corporate espionage. For example, backdooring sensitive information, not just from young users, but from corporate CEOs, researchers, people in academia, government officials on regulatory issues, as well as politicians. Would you agree that the guidelines for the National Security Review seem to point to the notion of a type of espionage, technological espionage?
Well, I don't want to interpret the guidelines that are used and interpreted by the government, but what I can say is our investigation is focused on the consent, on the appropriate purposes, on the privacy practices of TikTok in terms of, and you're right, not just younger users, all users. We are in the process of investigating this. We will be issuing our findings.
I'm going to ask you a couple of questions because I want to make sure we get to the heart of the matter here. So I'm going to ask them fairly quickly. Have TikTok representatives, either through the Canadian subsidiary or the head office, cooperated with your investigation?
We have been working with them. We have been obtaining the information. I don't want to comment beyond that because the investigation is not concluded.
Does your investigation involve ByteDance?
We've made a statement on our investigation, what it covers. It is looking at the privacy practices of TikTok. I can refer back to our statement.
Is it nearing?
It's
Is
ongoing.
it? No, sir. I really need to get these questions in, and you're just kind of drifting on some of these answers. So let's focus in. Is the investigation nearing completion?
Yes.
When will the report be issued?
I hesitate to give a specific date. This is a joint investigation, but we are pushing to moving it along as fast as possible.
Has the Minister of Innovation, Science and Industry, has their announcement ordering the windup of TikTok in any way impacted your ability to investigate?
I wouldn't be able to say yes to that. No, I think we're moving along with our investigation at this stage, and we'll be concluding it as soon as we can.
Okay. Do you feel like you have the power within the mandate of your office to adequately access the information needed to have a full and complete report?
We are moving along, and I'm not calling for more powers in terms of enforcement during the investigation. I'm calling for more powers at the end of the investigation.
And what would that look like?
So I'm calling for order-making powers. If I find a breach of the law, to be ordering an organization to comply with my findings. I'm not calling for powers of investigation. We have those powers already in the law.
So then why call for it after if you're claiming you already have them within the law?
We have sufficient powers in the law to do our investigations. But once the investigation is completed, if I find that the law was not complied with, I don't have the authority to order the organization, for instance, to stop doing something, to change its privacy practices.
I understand.
That's the challenge.
Thank you.
Okay, thank you, Mr. Green. That concludes our first round. We're going to start our 5-minute round now with Mr. Caputo. And before you begin, Mr. Cooper, I was going to congratulate you on your bold choice of a tie today, Mr. Cooper.
You're right.
I like it.
Bold is a different.
Mr. Cooper, you have 5 minutes. Go ahead, sir.
Thank you, Mr. Chair. Commissioner, you had indicated that your office learned about the government's decision to order the closing of TikTok's Canadian subsidiary, TikTok Technology Canada, at the same time that the public found out about that, correct? That's correct. And has the government provided your office with any further information since that time?
Not that I'm aware. I perhaps at the staff level, but I could confirm that. I don't think so.
Okay, thank you for that. And we have a rather interesting situation insofar as the government has proceeded to shut down TikTok's subsidiary. They have withheld from Canadians the rationale for doing so, citing national security risks that they claim are so severe that they can't be shared with the public and evidently can't be shared with your office. Has your office attempted to acquire further information as to the rationale for this that might be pertinent and informative to your investigation?
Not at this stage. We're focused on concluding our investigation.
But do you not see that there might be information that could potentially be relevant?
At this stage, we're content with the process of our investigation.
Well, yeah, okay, thank you for that. But going back to my point, we have the government saying, we're shutting the office down. We have national security concerns. These concerns are so serious, we can't inform the public. It sounds like the government isn't that interested in sharing anything with your office. But at the same time, it's so serious that Canadians can continue to use TikTok. I would submit that it doesn't add up. It doesn't make sense. And I guess when you look at the concerns that the government has that have been identified, I would submit there are legitimate concerns about the fact that TikTok, being owned by ByteDance, a Chinese company, could theoretically be required to turn over data and other personal information of Canadians to the Beijing-based regime. In that regard, I would note that Article 77 of the cybersecurity law ensures that data is collected and stored in China, and that when it is ordered by Beijing's Ministry of Public Security, it must be handed over, period. And so that theoretical concern is there. Do you have any evidence that it in fact is happening? Because TikTok came before this committee and was absolutely adamant that such information has not been shared with the Beijing regime.
Well, I think, again, this is an area where I can't venture because we are currently investigating. So if it comes up, this would be something we would indicate in our final report.
Thank you for that. Shutting down the subsidiary of TikTok doesn't change the fact that Canadians are as vulnerable to such information being shared with Beijing-based regime, does it?
Well, the app continues to be available,
right,
and
so,
Canadians can continue to use it.
So Canadians face the same risk.
Well, that's courts have found that Canadian law will still apply if Canadians are using it, even if you don't have a.
Yes, but as you noted, Canadian law still applies where there is a reasonable and substantial connection. But as you also said, your enforcement powers, or the ability of Canadian courts to enforce matters and decisions, don't exist for all intents and purposes in in the country of China, controlled by the Beijing-based communist regime. So, again, my point with that preamble is simply this hasn't changed a thing from the standpoint of protecting the privacy of Canadians, but what it has done is muddied the waters in a considerable way. The government has been completely lacking in transparency, and it's completely unacceptable.
Thank you, Mr. Cooper. Ms. Shanahan, for 5 minutes. Go ahead, please.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. I can't help my colleague clarify the situation because clearly the order to shut down operations refer to business operations, that's clear. And thank you, Mr. Dufresne, for making that clear earlier. It was done under the Department of Industry and Innovation and not under your office. Two things can happen at the same time, right? I would say that in the world of social media, often many things happen at the same time. For people who still have doubts, I have some advice. TikTok is a Chinese company, and if you have any doubts about it, don't download the app. It's simple enough. I would like to talk about a much more widely used app. That's Facebook. Now Meta. It's very popular in Canada. I have my accounts on it, as do my children tell me that my accounts aren't that interesting, my pages aren't that interesting, and that's how it is. But it is a way of sharing personal things like photographs. And it's also a way to communicate with the public, with the community. Mr. Dufresne, a very interesting decision was just handed down, and I think you and your office were involved in it, a decision involving Meta. Could you please tell us about that? Are you satisfied with it? Does it show that your office indeed has powers? If you're talking about the settlement in the class action suit, we were not involved in that. That's true. That was in 2018, a class action suit. We did carry out an investigation regarding the Cambridge Analytica scandal, which involved Facebook. We don't have the power to issue orders, so we had to go before the federal court, present the case, and the Federal Court of Appeal did recognize this fall that in the Cambridge Analytica file, consent had not been properly granted. In the case of Cambridge Analytica, and Facebook is now trying to get the case before the Supreme Court to overthrow that decision. Overturn it, rather. It's not that long ago, 5 or 10 years. We had no means to deal with the web giants like Facebook. But now we've seen in 2 cases, and I'm sure there will be more, that your office and users can take action against Meta. Can you comment on this in more detail? I understand that you can't say much yet about the TikTok case. What I can say about the Facebook case is that it shows that the system and the regulations can be applied. We can obtain decisions, but it takes time. If we go back to Cambridge Analytica in 2018, it took time. It would take less time if I had the power to issue orders. That is, in fact, what your committee recommended. That's the challenge I'm seeing, because technology is moving forward very quickly. Websites are evolving very quickly, so we need to be able to have a faster application of decisions. Yes, I agree, because we see the tactics the web giants have been using, particularly bullying, blackmail, threats. It's extremely disappointing if we go back to the past when we were dependent on railways and other means of communications. It's important for the government to protect people. Do you think the current legislation is enough to do the job? I know you have very little time to respond. I think we need to modernize both the public and private sector sides of the legislation. There is protection on the private side, but less on the public side, so parliamentarians do have to act. Thank you. Mr. Villemur, 2.5 minutes. Thank you, Chair. We'll keep our questions short. So legislation focusing on the public sector is essential, yes? As you've said before, issuing orders and imposing penalties, that is something you believe is essential to your work. It's essential both for the private and the public sectors. Is the concept of privacy as a fundamental right enshrined? If that were enshrined, would that be useful to you? Yes, and we've recommended that for C27. The committee approved the recommendation, but it should be in both statutes. Let's say we ban TikTok, the app itself. Would that provide more protection for Canadians' privacy, or would it not achieve much? What we look at is whether its use is in compliance with the law. If it isn't, we want corrective measures to be taken. In an extreme case, there might be a case for banning the app, but it's better to say change your practices, clarify consent, and so on. ByteDance has admitted that data are stored in the U.S. TikTok has, they said, been establishing better structures. Was that done in Canada? I can't comment on that specifically. We're investigating TikTok and its practices. Today we're talking about TikTok, but colleagues have also talked other platforms. Are all platforms a hazard to public life, or to privacy rather? Every platform has its practices. We receive complaints. Today I announced that we'd had concerns about LinkedIn and what they used to train AI. They responded well. So that's an example. Sometimes we don't need a full investigation. Sometimes with dialogue we can achieve things. Thank you.
Mr. Green, you have 2.5 minutes. Go ahead, sir.
That's a great segue with my comrade from the Bloc Québécois. Looking at the other comparators, have you in your time, Mr. Dufresne, been investigating the other platforms, X, Instagram, Twitter, and the like? Have you had a chance to review the privacy concerns around those companies as well?
So we've been focusing. We have a complaint with Meta, Facebook. We have this one, and we had the announcement of our decision on ALO MindGeek. So those were the big ones that were concluded and made public.
And in your estimation, do you see commonalities in terms of the themes and the way in which privacy breaches are prevalent in what is otherwise a form of kind of surveillance capitalism?
Well, one of the things that we've seen, and we've seen it this summer, we have done with international partners and with partners in Canada what we call a privacy sweep. And in this year, we did this not only with privacy authorities, but competition authorities. And we looked at what we call deceptive design practices, which are practices where an organization is going to use tools to manipulate users into making choices that are not in their interest. And
is that report? And so in that report, did you find some of these platforms to be more egregious in their use than others?
Well, what we found, sadly, is that the 97% of the organizations and sites that we looked at, and we looked at a lot of them, they had at least one of those bad practices in terms of having language that's not clear.
Just getting back to comparators, I want to focus on that for a moment. Obviously, we have lots of platforms, all of them providing business models in very similar ways in terms of how they advertise, profile, understand the end user. And yet TikTok was singled out and banned from this country without, I would argue, without a real full public disclosure. In your estimation, do you believe that it's important for the public to fully understand the impacts on their privacy by the use of these platforms? And I would add, do you think that given the fact that TikTok has been banned, that the government has a duty to report back to the public as to why?
Well, I think transparency is important. I think the more the public can understand about the decisions of the government, the decisions of my office, the better. There may be some limits in terms of confidentiality, but certainly this is important. We initiated this complaint, this investigation vis-a-vis TikTok, in particular because of the high number of younger users on the platform. And so that is a strategic priority that we have. And so we're moving forward on that and hoping that our conclusions on that will be beneficial to others who may have similar practices.
Okay.
Thank you.
Thank you, Mr. Green. Mr. Caputo, you have 5 minutes. Go ahead, sir.
Thank you very much, Mr. Chair, and I want to thank our witnesses again for being here. It feels like it's a bit of a regular occurrence as a relative newcomer to this committee. Now, I just want to pick up where Mr. Green left off. Something I found interesting, Commissioner, is what you said, that younger users are targeted. But it seems to me that social media generally targets young users, period. I think we can agree on that, right?
Well, there's targets all users, but I don't think I said it targeted younger users. There's a high number of younger users. So
those are my words, higher number. Now, when it comes, though, you've got several issues with privacy. You've got issues with privacy that are contemporaneous with use, And then you've got issues with privacy that exist regardless of whether someone uses, as in tombstone information, that type of thing. Do you get what I mean by that? Yeah. So obviously younger users become older users. So would the concerns not be the same across social media platforms that would apply, because even despite the fact that TikTok is targeting younger users?
Well, we've made the protection of children's privacy one of our priorities, and that's something that's shared internationally. So we did it recently with the G7 counterparts. We issued a statement saying, build AI with the best interest of the child at heart. So ask yourself, there will be some different considerations. We call upon stronger privacy protections for younger users, stronger rights, for instance, to deletion of information that might have been posted as a child. And that's what I meant when I said children have the right to be children. If you hold them to the same level of accountability as adults because you're leaving things forever, that's a challenge. So we're looking at that. We're looking at making sure that that lens of children's best interest is always there, and that those privacy protections are stronger by default.
To the best of your knowledge, where is the data for TikTok stored?
I'm sorry, I didn't catch the end of your.
To the best of your knowledge, where is the data for TikTok stored?
This is getting into sort of factual questions that we're investigating that, so I can't be speaking on those things at this time.
Okay. I mean, it seems to me that would be part of the transparency that I hope we would see. I didn't think that was a question in dispute, but obviously it may well be. So I'll pivot to this issue of transparency. Now, my colleague, Mr. Cooper, spoke about the failings of the government, and as I understand it, there are two parallel issues. You've got the government winding up the TikTok, I won't say brand, but whatever business entity in Canada. And then you've got a related issue with your investigation. And as I understand from what you said to Mr. Cooper, you are not privy to the government of Canada's, I guess, rationale for winding up TikTok. Is that correct?
Not beyond the public statement.
Okay. And you said, if I understood you correctly earlier, that you would be completing your investigation, notwithstanding whatever the government of Canada has decided. Is that right?
Yes, we're moving forward with our investigation. And again, whatever information we may need or obtain in the meantime, we would do that, and we would finalize the investigation. And then those findings are going to be made public and the full rationale at that time.
Okay. Wouldn't it make sense to, at the conclusion of your investigation, which you've done independent of the government's, I guess, their rationale, wouldn't it make sense to go to the government and determine what and the reason why to further inform your decisions in order to determine whether further investigation is required? It's almost as though you're operating in a vacuum that has maybe 70% of the information.
Right. Well, I think, again, this would be part of the decisions that we make in the context of that investigation. If we decide, well, we're going to reach out to X to obtain this information and to inform our findings, that may occur, and then we would make that public at the end of the investigation once it's concluded.
So you may actually reach out to the government to determine its rationale?
Well, what I'm saying is I'm not confirming the investigative steps that we've taken in the past or that we would take in the future. The investigation is ongoing, and we want to conclude it as soon as possible and have those findings for Canadians.
No, I understand that, sir. I'm just trying to probe, I guess, the depths of the investigation, especially as it relates to national security. It would seem that would be a necessary step. I'm not trying to challenge or suggest your investigation won't be fulsome. What I'm saying is that it seems to me that the national security element and the privacy element really would at least potentially go hand in hand. So I'll leave it at that.
Okay. Oh, go ahead.
Very limited in terms of what I can say about the conduct of the investigation as it's underway.
Understood. Mr. Fisher, 5 minutes. Go ahead.
Thank you, Mr. Chair, and thank you, Commissioner, for being here. Just when I start to think I'm starting to get a handle on some of this, I get a little bit confused, and I got confused there at the end by Mr. Caputo. Can you clarify that the ICA review is completely unrelated to your investigation?
The ICA review yes, it's completely
Okay.
separate.
All right, thank you. Going back to, and I think Mr. Barrett might have talked about this a little bit, realistically, under PIPEDA, for both Canadian companies and foreign companies, what can you do if they fail to provide the requested information you need? Now, you talked about jurisdiction, then you talked about enforcement. Realistically, what can you do for a Canadian company with a Canadian subsidiary and a foreign company without one?
I think the big difference is if we need to compel, if there's a lack of collaboration, and then we need a court order to order the disclosure of something. So that can be easier if the entity is in Canada than if it's not. So that's where this would come up. Under the law, I have powers to order a company to give me documents or to provide access with some of its information. So we can exercise those if a company is in Canada. If a company is not in Canada, then that can raise different questions.
But you could do that through international cooperation, through MOUs. You could do that through the courts. Like, we've already seen successful court cases, right?
Right. So if something is in another jurisdiction and you need enforcement, then you seek that from the courts of that jurisdiction.
So realistically speaking, then, if TikTok were to close up shop in Canada, still do something negatively to impact Canadians' privacy, you do have the ability to enforce PIPEDA, but you need to do it through an MOU or through the courts.
Right. If PIPEDA applies to something because there's a real and substantive connection to Canada, then we can get an order from courts. The question becomes making that order recognized in another jurisdiction. And as you say, this could be done by MOU or by international recognition.
Okay. So we talked about, I think Brenda talked a little bit about the Facebook versus Canada case. And you said it was a very important ruling where global tech giants whose business models rely on users' data must respect Canadian privacy law and protect individuals' fundamental rights to privacy. So how does this case affirm your oversight and jurisdiction over foreign entities, and how does it affirm your jurisdiction over tech giants that have deep, deep pockets, been willing to spend a ton of money, and have, historically acted bullishly both in Canada and globally?
Well, courts in Canada have recognized that because of the nature of data and because of the international relations, it's not necessary for a company to be domiciled in Canada for Canadian courts to have jurisdiction. So that's the real and substantive connection test. And so courts have recognized this. If Canadian users are impacted, Canadian institutions will have jurisdiction on it. And so that's why in a case like Facebook, in other situations, we are able to assert jurisdiction independent of whether an organization is in Canada or not, provided that Canadian users are impacted.
Can you tell me a little, excuse me, I haven't coughed in a week and now I'm coughing nonstop during my chat with you. Can you talk a little bit about the Facebook case that where they refused to say that they did anything wrong, but made, I think it was a class action suit, paid $9 million to some Quebec educational entities?
Right, so that's a class action settlement that is distinct, that we were not involved in this matter. So I think what this highlights is that we need to have the ability in privacy law for my office to be able to issue orders and to issue fines, because we see the impact that these financial amounts can have. Now, ideally, they won't be imposed because organizations are going to do the right thing, but it helps decision-making. What we have now under Canadian law with our Facebook case is we have to seek an order from the court and to push in that direction. And so far, we have not obtained a financial compensation in that case, although I will continue to push for that.
So this may not be a totally related question, but I'm wondering how, if they refuse to admit any wrongdoing and they take their deep bank accounts and throw a little bit of money at something to make it go away, and it does end up going away. How does that get us to a point where we, moving forward, can get them to act less, I used the word bullishly. How do we get to that place where we actually, because I think until we have a court case where we truly have someone say, okay, we screwed up, we're wrong, you know.
There are a number of tools that we can do that with legislation. If you amend legislation as a parliament and you provide certain specific requirements, then that has an impact on organization. You have an impact with international dialogue and collaboration. So we're working very closely with the G7 colleagues, with the international colleagues. We're making international statements on AI and good practices. And then if you have a court order, one of the reasons I'm advocating for order-making power and fines is that then you have an order that says, here's what you need to do. You have fines which focus the mind, and then you can use the promotion work as well to really build that culture of privacy.
Okay, that's it. Thank you, Mr. Fisher. And I did start your clock a little bit late, so you got the 6-minute round on that one, so plus. Yeah. Okay, that concludes our panel. Mr. Dufresne, I want to thank you. Monsieur Chenier, merci encore pour d'être ici.
Mr. Chenier and Mr. Fisher, thank you for being here today.
And this was a fascinating discussion. Just to let committee members know, on Thursday, we'll have CSIS here as part of our study. They'll be here in the second hour, and H&R Block are coming in the first hour in relation to the CRA study. So I have no other business ahead of me. I am going to adjourn.